today's webinar, our live, for those of you joining us here on YouTube, we were streaming across multiple platforms. That includes Instagram Live as well as Facebook Live. We discuss how to be successful in your criminal case. Okay, and so that is a challenge. This message today is for doesn't matter if you are pro se, doesn't matter if you are represented. There are some strategies that are going to help you in terms of being successful, help you advance your case in a way that's going to hopefully set you up for success, as opposed to other ways that are going to hamstring you or that might actually derail your case. And so, one of the goals today is to share some information with you, again, whether you're represented or you're unrepresented, that is going to hopefully help you as you begin to navigate these what can be very, very treacherous waters when we talk about the criminal justice system. Okay, so let me be first to welcome you. My name is Genghis Shakan. I am one of the attorneys in a tandem Shakan and Wilkerson law firm. I work hand in hand, side by side with my partner, attorney Chelsea Wilkerson. We do both family law, divorce cases, men's rights cases, as well as criminal defense cases. Okay, so we take on misdemeanor cases as well as felony cases. So we can handle pretty much everything in those two respective areas for you. We're full service. One thing I will say is that we are a boutique law firm. Okay, so there is just being that there are the two of us and our team. We are a fairly small venture, and because of it, we give more personalized attention to our clients, which they greatly appreciate. We have weekly office hours. We also have a small university, and when we talk about the university, there are videos that our clientele have access to. Okay, and so one of the things we want to be sure to really kind of impart is that if you do need counsel, we are here for you. You can reach out to us one of a few ways. Let me give you one of our telephone numbers. Metro Atlanta 404-999-9529. And then if you are in the middle Georgia area, 478-845-1213. Okay. But we do serve all of Georgia. So not just Metro Atlanta and not just middle Georgia. So if you need us, and if your case is one of those that we could take on, we'll be happy to help you out. You can also go to the link in our bio. You can tap on that, and you can also register for schedule a consultation that way. You'll also find there's a lot of resources. We offer a lot of blogs. There are some free handouts, and in addition to that, we do have two books that are available for sale on Amazon. And I think if you go to the link in the bio, there may be a link to those books as well. Okay. So do take a look at those things. Again, just hit the link in the bio if you are interested. Again, today's talk is specifically about how to be successful in your criminal case. So again, I welcome everyone across all platforms. You specifically here on YouTube. Thank you for joining us. Okay. So as I mentioned, this is for folks that have been charged with misdemeanors, folks that have been charged with felonies, and whether you are pro se or whether you are represented. Okay. And so, as I explained earlier in the live on Instagram, this is not about the truth as it is as much about evidence. Okay. And I'm going to explain that and tell you what it means. It may sound a bit confusing, but it's not. And this is the way the system essentially runs. This system runs on evidence, okay, and procedure as well as strategy, okay. And so that understanding all of that, there are good people who lose cases all the time, right? And so hopefully that's clear to you. Obviously, there are folks who are locked up or detained that are innocent, right? So that comes with kind of the way that the system is set up as an adversarial system. I can't say that the system is set up to really I guess, bring and invoke the truth as much as it is adversarial. And so it's set up about who, a presentation of evidence, right? And who can essentially make the stronger case. And so, as I mentioned, it's an adversarial system. And so that's something that, you do want to be mindful of at the outset, right? As you kind of go through this process. Again, as I said, good people can lose cases if they don't understand that process. Okay. All right. Now let's go ahead and do a deep dive. What are some of the things that you don't want to do if you have a case, right? You've been charged with the case. Here are some things you just don't want to do. Number one, and you hear this all the time, is talk to the police, right? That's the simple one. Don't talk to the police. Okay. If you've been arrested, you need to exercise your right. There's one right that you have is a right to remain silent. Okay. And so talking to the police is one way that we have found um, that people can derail their case. All right. And one of the things they try to do in having that conversation with the police is they want to explain their side. Okay. If you haven't noticed, many officers that come on scene, um, kind of center body mass, they will have a camera. Okay. And you are on candid camera. That camera is recording. Right. And so as you are attempting to explain, you may be saying things that are going to injure your case, okay? Or things that might be harmful, or things that your attorney wished that you had not said. And so you want to be mindful of, not and exercising your right not to speak when you're having these interactions with officers, okay? Is that you don't need to explain your side to the police officer. There is a judge or a jury that's waiting at the end of your case for some type of explanation from your counsel, right? And so that comes a lot later. Again, posting on social media. You want to avoid posting on social media if you have been, let's just say, charged with the crime and you've bonded out, right? And you get on social media and you're talking about your case. Guess what? You have generated some great evidence to be used as exhibits later on in a court of law by the prosecutor, either the solicitor or the assistant district attorney. And they're going to bring it back up, right? And all it does is it harms your case. Stay away. If you're charged with the crime and you're on social media, do not discuss the details of your case. Okay. It's just there's no benefits. There are no upsides to it. Okay. The the what public opinion is regarding your case is not going to matter at the end of it, when it comes to, really adjudicating the matter. So that's something else you do want to be mindful of. The other thing that gets our clients in trouble all the time, I don't know if we just don't emphasize this enough. Do not discuss your case on the jail phone. Okay. Um, those lines are recorded. They tell you that as soon as you pick up the phone and try to make your connection with the other party. All right. The phone, there is a prompt that says, hey, these calls are being recorded. Believe me, believe them when they tell you that the calls are being recorded. Do not, under any circumstances, get on those telephones and begin discussing your case. Okay. It will likely be used as an exhibit. You will hear your voice again in the courtroom, and the prosecutor will be playing whatever it is that you said that was damning regarding your case. And, if it's admissions of guilt or if it puts you on the scene, at the scene, all of that stuff is going to be harmful to advancing your interests. So do not discuss your case on the jail phones. Then also a big one is do not contact the victim. right? If there is a victim in your case, and usually at that initial appearance, the judge will let you know. The judge will say it, from their own mouth. Magistrate court judge, whoever you're standing tall in front of, will say, "Do not. There's a victim in your case. Make contact with this victim." Right? They'll name the victim, or if you're not to go to a certain address, all of that will be spelled out. Let's just say that you do get a bond. That might be part of the special bond conditions. Okay, do not make contact with the victim. And we have folks that, commit double whammies. Not only will they make contact with the victim, they'll call the victim from the jail phone. Okay. And so the judge was very clear. The bail bondsman was very clear. Do not make contact with this victim. And we'll talk a little later about how that harms your case. But those are the things that we see most often, that usually can derail a case. All right, so let's just be mindful of silence, and you have to understand this: silence is a strategy. Okay, and your attorney or your counsel will explain and expound upon that a bit more. But silence is a strategy. Stop talking. Okay, if I knew sign language, I would say it in sign language to my clients, right? I'd write it in graffiti. I'd maybe smoke signals. I don't know how to convey the importance of not bumping your gums on the telephone, jail telephone, to the police officers, explaining your side, or on social media. Just don't do it. Okay? Going to harm your case. All right. So let's talk a little bit about your rights. And these rights are covered usually if you've been arrested within 48 to 72 hours, you're standing tall before a magistrate court judge at the initial appearance. And they're usually covering a lot of these rights. One of your rights is to, guess what? It's going to be a recurring theme in this discussion today, is to remain silent, right? And so that'll be one of your rights, and the judge will probably speak to that. You'll also have a right to an attorney. The other right that you have, especially if you are being stopped on the street by a police officer, is you have the right to refuse a search, right? So sometimes people feel like they are being pressured to consent to the search. You have a right to refuse a search, right? In many instances, doesn't mean that an officer won't have a right to essentially facilitate that search, but just understand that if you are asked, you do not have to consent to a search. So, an officer might, for example, ask to look in your trunk. Can I look in your trunk? Do you mind opening the glove box for me? Right, and you can decline. Okay. Now, of course, understand that there might be situation, where things might involve officer safety. It depends on the details and the context of the situation where a search might be warranted. Your counsel will let you know kind of where you stand regarding the legality of the search. That is what you are retaining that attorney for, or that is what the public defender is there for. And that is a conversation that will be had between you and your counsel. So you can refuse a search, and then the other things that you have rights to, if you have rights to hearings, okay, and that all comes at a later time. And your counsel will kind of provide a roadmap for you on what you can expect as your case matures and moves along. All right. Now, if you are detained by an officer, um, essentially, if you have to say anything, you can say, "Hey, I want a lawyer. I'm not going to answer any questions." Okay, and that's I think that's a fairly good statement. Okay. All right. So regarding strategy and the basics, regarding every case, there is going to be timing, evidence, as well as positioning. Those are the three things for success when we think about how we are going to advocate for our clients. So timing, early decisions in a case usually matter. And so those first 72 hours. All right, my apologies. Okay. So timing is where I left off. Then of course there's going to be the evidence. Okay. So what does the state actually have? And so getting evidence from the state is like pulling teeth, right? Statutorily. Okay, I think we're back. All right, statutorily, your counsel is entitled to discovery documents, is what that's called regarding, getting the evidence over. Sometimes that comes very late in the case, okay, and many times that can infuriate not only your counsel, but make the client upset as well, because the prosecutor is less than forthcoming and getting that information, those documents over, evidence, interviews that might have taken place, videos, audio, whatever it is. Sometimes it could be terabytes of information they may plan to use at trial, right? And so all of that is also going to be important in negotiations, okay? When we start talking about a possible plea and really weighing how strong your case is. And so evidence is really important. So it's not what the prosecutor is saying, it's what exactly they can prove. Okay. And so that's the important part, is what can they prove? And then positioning, and this is something that we try to coach our clients about, is how you present yourself in court. That's going to be essential when you talk about especially a jury trial, because usually the defendant is not really on the witness stand. And so the jury will have to form an opinion of the witness based on perhaps testimony from other witnesses or statements from other witnesses, or any kind of evidence that might be put on. And so the defendant, our client, is always under the watchful eye of both the jury as well as the judge, right? If there are certain motions that are being heard in front of a judge, okay? And so some of the things we try to talk to our clients about is courtroom behavior, coach them up about what that needs to look like, complying with judge orders. So again, we talked a little bit about, remember, those bonds, right? And so there are conditions in those bonds, and sometimes if a client hasn't complied with those conditions, or maybe there was some kind of a condition that the client was released under. Maybe folks were supposed to go to anger management classes or do community service, right? If you're maybe you have some probation conditions that are out there that exist, and so it's essential that those things get done, right? Maybe you're supposed to submit to drug screening, right? Fourth amendment waiver, maybe you're supposed to submit to certain searches, right? And so there are things that you want to be mindful of as your case is moving along, that you want to make sure that you are in compliance, full compliance. It all it does is help your case, right? It doesn't put you in a situation where the judge might find that you are not compliant, or worse yet, the jury may feel like, hey man, this guy is not a stand-up person. Okay. So something you want to think about. Then also is going to be your attitude in court, what it is that how you make jurors feel, and then how you might make the judge feel. Those things are really important as well. Okay. All right. So let's talk about pro se versus represented clients. We talked very briefly about that. I just want to kind of hit on that really quickly. In some of the advantages and disadvantages, if you are pro se, there is a reality that you have to be mindful of, that you are going to be probably held to the same standards as an attorney. Okay. So those same standards. Okay. So a lot of judges won't throw you softballs, if you're trying to put on evidence, if you are doing it incorrectly, you may hear a lot of objections from the prosecutor, right? And so things that are essential to your defense, if it's done incorrectly, it might put you in a position where you are more than likely going to lose your case. Okay, and obviously, who knows what the stakes are, depending on whether it's a misdemeanor or a felony offense. Okay, so just be mindful that you are going to be held to the same standard more than likely as an attorney. There are some judges that they do understand that as a pro se litigant, you may not have a mastery of all the procedure, of all the rules, because there's a bunch of rules, right? There's superior court rules, and there's all kind of statutes and case law, and you may not have a grasp of the stuff that's most important, but they might give you some grace. And then there are others that will just tell you, hey, if you didn't understand all of this, you probably should have retained counsel. Okay. And so, the metaphor I like to use is, I don't know how to work on car engines. I could go to AutoZone and grab an air filter, oil filter, some oil, climb under my vehicle, and you know whatever kind of changes or whatever kind of improvements I feel are needed in my vehicle, go ahead and do that, and whatever maintenance is needed. Now, I can tell you that it's probably not going to end well for me. On top of it, I'm probably going to cause more damage than good. So, because that's not an area that I have any expertise in, and I don't know that Chat GPT is going to get me where I need to be to close, you know, the um, the gap of ignorance before I climb up under the truck to try to facilitate that maintenance. So understanding that, you want to be mindful of those things before your case kind of kicks off. Sometimes people really late in their case are trying to retain an attorney, and sometimes by doing that, it kind of puts you at a disadvantage. So you want to keep in mind, you're going to be held to those same standards, and what that means is you might miss out on some potential defenses that you might have been able to. You might be waiving certain things. You may enter into bad plea deals, and you just might make some procedural mistakes, which could impact you, and if you have to appeal your case at a later time and date. So those are the disadvantages of not having counsel. Most people will have counsel even if it is a public defender. Of course, if you have a misdemeanor case, you may or may not have counsel. And we'll talk a little bit about that here next. The advantages of having an attorney they're pretty obvious. An attorney is going to probably have some strategy, or some way to see if they can either a mitigate the damage or a way to prevail in your case. They might be able to enter into negotiations with the prosecutor. A lot of times, prosecutors are more likely to negotiate with a criminal defense attorney than they are a pro se litigant, right? And then the evidence challenges, right? So if you do make it to trial, there are things that or even pre-trial, there are things that need to be challenged in order to put a client in a position to potentially prevail, right? And so, if all the evidence is kind of coming in, sometimes that might be a bad sign, right? So having counsel there to hopefully keep certain things out is going to be super super helpful. All right, so we are rounding third now. Let's talk a little bit about misdemeanors. Okay, so a misdemeanor, obviously, when you talk about penalties, you're looking up to 12 months in jail. Now these are still serious, right, in terms of the time, because one, you'll have potentially, something that's going to be on your record, which is going to impact things like, job opportunities, housing opportunities, and those types of things. So even though the charge might be small, the consequences can be big, right? And let's talk about felonies. Felonies, the obvious thing that's on the line is the prison exposure, the amount of time, right? So you're looking at more than 12 months, depending on the infraction, just how egregious it is. You could be looking at decades of your life, right? Or you could be looking at your life, right? And Georgia is one of those states. Okay, so you want to be mindful of that, especially if you have serious felony charges, that you are gambling if you don't have competent counsel up there, and you are the tokens, right? Because it is your life, it is your freedom, and you will probably not get a do-over, right? Not at least in the way that you would like. So it's important that early intervention, getting counsel involved early in your case, and having an aggressive defense and an aggressive attorney is going to be very important to you, as your case really kind of starts picking up some steam. Now, here are the common mistakes that we see in these criminal cases. Is a lot of times folks are just talking too much. They are oversharing, and it's just not benefiting in them in any way. There is no return on investment for oversharing. Matter of fact, in many instances, all you do is dig yourself into a deeper hole and give the prosecutor more firepower against you. Waiting too long. We talked about that briefly earlier. Some folks will just, they'll wait until the 11th hour to bring counsel on. At that time, it might be a little late in the game. Things might have been waived. The case against you might be fairly strong. No, your negotiating power might be greatly reduced. And then maybe your defense attorney can only do maybe a little bit of help. But that's the risk of waiting, or working the case pro se for 50% of the case, 75% of the case, 90% of the case. Sometimes I've gotten calls the night before trial. And so and in those situations, that's a Hail Mary. Okay. You don't know what you're going to get. It's a mixed bag. All right. So waiting too long, ignoring court dates, and violating bond conditions. Talk a little bit about violating bond conditions. Usually, condition one is not to violate any other laws, right? And so people violate probation all the time, and so you have to follow the rules. You have to, basically remain in compliance. If you are not, what ends up happening is you find yourself basically right back behind bars. And this time you might stay put until your number's called, right? So sometimes these cases can take years to adjudicate. Okay. So making sure that you are following the rules, and that's going to help you in the long term with your case, in front of a jury, even in front of a judge. If you have been compliant, you have done everything that you have been asked to do. It says a lot about your character. Okay. All right. I'm sharing all of that to let you know that a lot of times these cases, folks hurt their case rather early, right? And they really hurt their chances pretty early in a case, and this happens well before they ever make it to trial. Okay, as I mentioned, a trial, some jurisdictions are backed up. A trial can be years off, right? It can be 2 years, 3 years off. And so you want to be mindful of basically, doing everything that you're supposed to be doing up until your trial date. All right, so here's a simple roadmap. If you've ever been arrested, you have a family member that have been arrested. There is the arrest, the initial appearance between 48 to 72 hours. After that, we're talking about bond, right? If you get bonded out of the jail, or if you motion for bond and the judge releases you on bond. From there, you need the investigation phase. your counsel, the opposing side, the prosecutor is investigating a case. And then after that, you have negotiations, right? So there are rounds of negotiations sometimes between the prosecutor and between your defense attorney. And then finally, you're talking about a trial or the resolution. Okay. And so those are, that is essentially what you need to know when it comes to being successful in the case. I wanted to drop in and make sure that you had this information. It's really important to us really share information that we feel like our community should know about, whether they retain us or not. That is our really commitment as I mentioned before, community service and serving a community. Again, this is whether or not you decide to engage our law firm or not. Um, so just your takeaway should be a few things. One, your case can be won or lost fairly early on, right? And so some of it is decided by, you getting counsel involved early, who you pick as an advocate for yourself, and then what's going to be the strategy, okay? So that's something that your counsel would have a conversation with you about, or if you are pro se, something that you need to be very mindful of, okay? And then what's at risk, okay? Understand by doing a cost benefit analysis. Sometimes people will say, "Hey, I don't know if I need counsel. I feel like this might be something I can do myself." That's really a you decision. Um, you have to determine what the value of your case is and whether or not it's something that you feel like you can really do by advocating for yourself. Okay. All right, if you need us, we're pretty easy to find. Two telephone numbers: 404-999-9529, and then 478-845-1213. You also have the link in our bio above. Tap the link. You can schedule a consultation that way, or you can give us a call and our receptionist will get you set up. We'd love to help you out. Again, if you have a divorce matter, a family law matter, a men's rights matter, if you're a man, or if you have a misdemeanor or felony case, right? And that includes DUIs. Feel free to give us a call. We're more than happy to have that free consultation with you and see if we are a good fit. Otherwise, hey, I thank you for joining us. Please make sure that you tap in with us on a weekly basis. If you haven't already liked our video, please like it. It's been helpful for you. And then make sure you follow us because we will be doing weekly webinars, and we'd love to see you and see if we can get some of these questions answered for you. We understand that attorneys can be pricey, so it's important to us that you, as I said, get access to information that a lot of our clients have automatic access to. Okay. All right. Well, my name again is Genghis Khan. It has been a pleasure spending this time with you. I look forward to seeing you at future webinars. Have a great one.